first question relates to the book Fictions of Justice, the International Criminal Court and the Challenge of Legal Pluralism in Sub-Saharan Africa, from Cambridge University Press. It just came out. So this work really is an exercise in studying up.
Studying up, I always put in quotes because, of course, as a concept that was coined and popularized by Laura Nader, in many ways it speaks to the history of anthropology, but it assumes a particular hierarchy, right? So when I talk about studying up in my work in relation to studying up, I'm referring to an established hierarchy. There are lawyers in society who participate in establishing legislation and put in place policies that have an effect on people who are not involved in that sphere. One of my research questions was to understand what are the circulations, what are the interrelationships between those who are participating in sort of this public forum, right? This terrain in which policies are being established, in which laws and treaties are being signed, etc. What is the relationship between the knowledge that shapes treaties and rules and laws that are established in these international contexts and their connection to those people who, I guess, would be seen as those that are part of the studying down, quote unquote, right? As problematic as it is as a concept, it reflects a fraught history in anthropology and in a history that many of us are trying to rethink, both conceptually as well as in practice, that the ways that knowledge flows, the ways that we understand transformation and change in our social world requires that we understand both actors who are working in the realm of policy and law as well as those who are sometimes not working in that realm but are affected by and are also influencing in different ways these realms. But in my own work, of course, I studied lawyers, diplomats, trainers in international context, NGOs, people who are actively engaged in this arena of international criminal tribunals.
What did you find in terms of sort of mapping global power structures and looking at the ICC?
How does it work then? What did I find?
Yeah.
Well, the title of the book is Fictions of Justice, and one of the things that I wanted to demonstrate was that we often talk about justice as if it is a concept that should be assumed, that we all know what justice is. And one of the things that I found was that, in fact, the meaning of justice is as different and diverse as anything else is, right? Any other concept that, derives from different histories and different people and different places. There is no agreement on what justice is, and in fact what we have is this notion of justice that is a reflection of knowledge and power. What we declare as justice is a manifestation of the power of those who believe that some kind of result is a justice result to influence others through their political prestige or forms of power. The concept fictions of justice, that ultimately justice is simply a construct that is produced as justice, and it is a function of knowledge and power that circulates in particular domains.
Is there a sort of colonial element to this construct of justice at the ICC?
No, I'm not arguing that there's a colonial. It's not as neat and tidy as that. But the question whose justice is an important one. Colonial histories are part and parcel of the ways that legal systems have been shaped. That we know. But I don't say that this is simply a colonial justice form, since, as we know, culture is dynamic. There are colonial inscriptions, there are structures around which certain legal forms have traveled to various regions, and then there are adaptations that local people, that people in particular regions make to make sense of or to implement or operationalize those legalities. So it's a combination of the colonial past, a pre-colonial past, and a contemporary interpretation. And all of those things make it very messy. So it's not only colonial, it's everything mixed together. And I think that's the beauty of the kind of work that we're seeing today, where people are trying to understand the many complex ways that different interpretations and paths have come together to create the kind of legal systems that get interpreted as justice systems. I like the question, who's justice, as well. I have a piece that I submitted for a journal on who's justice, and it's a provocative way of questioning what are the sources of justice that we're seeing today, right? And what are the implications of of the source of a given justice regime. What are the influences that might come from elsewhere? And being able to answer that question, I think it's important for a number of reasons. For one is that if people don't see a justice system as their own, it will be alien to them and they won't respect it and they'll undermine it and they won't support it, etc. And we're seeing some of that in various places in sub-Saharan Africa. Uganda is an example of that, in which the ICC is at odds, at loggerheads, with various members of constituencies in Uganda who aren't supporting the decisions of the court. Others are. It's complicated because it's mixed. There are some who want the court to intervene. There are others who do not. And there are a number of reasons why. Those who do not see it as an alien force, right? They see it as yet another example of an imperial power that has replaced a colonial power that is simply trying to intervene and extradite their own citizens. For some, their own citizens should be tried on their own soil in Ugandan terms using justice mechanisms that are relevant, that are indigenous, that are related to their experience, not some foreign court elsewhere miles away that will extradite and use rules and laws that are outside of their own.
There seems to be we have a just process and therefore there's a just result. You touched on this in your book, that processual notion of justice. Does that hold in the areas that are affected by the ICC in sub-Saharan Africa?
What's important is for us to examine the rules of procedure and the subject matter jurisdiction that form the basis for process in the first place. The process by which certain crimes were included in the Rome Statute and other crimes were excluded. And what you have in Africa are contexts in which resource wars, drugs, etc. are part of the problem, but they're not part of the solution in terms of the subject matter crimes that are under scrutiny for the ICC. So what you have then is the exclusion of crimes that would be relevant and that would allow us to think through the basis under which certain forms of violence are taking shape on the continent. But we have an exclusion of that and instead an inclusion of particular other crimes that are probably some of the, might be seen as the most horrendous, but are far from a totality and are exclusive. So, no, there's a big problem, but that's what I'm calling a fiction of justice. It's that relationship that you highlight, the idea that justice equals process, due process equal justice. That's the fiction.
Your working title was Justice in the Making.
That was an earlier working title, that's right. And we changed that to Fictions of Justice, a more radical declaration of justice. But Justice in the Making was my way of talking about the active process of making justice. That justice it isn't a given. Justice doesn't simply equal due process. We construct the terms for justice. When you think about lawyers and the subject matter jurisdiction, there's a process through which the terms of inclusion are deliberated. And I'm interested in that early process, what we call the process of codification, the codification of law, as opposed to assuming that, law exists as a magical entity and it's simply a matter of executing and operationalizing law.
Now, you mentioned what becomes the subject matter of the ICC in terms of crimes is really, really important. The crime of aggression. Now that's been a stickler in terms of U.S. ascension to the ICC.
I actually was part of the crime of aggression working group when I was doing field work at the UN, and it was always interesting to me to hear the discussion, to think about the considerations, the issues, the forms of classification for what constitutes aggression. It's something that I'm continuing to watch and examine, and it's unfolding as we speak, right? That in another year, the ICC will revisit its statutes and probably will write about that a bit later on. Certainly an interesting one, and it's one that I've been tracking over time, but it has yet to really unfold as an operational category for crime. In many ways, it leap of faith for many countries that have signed and ratified the Rome Statute. They were unsure of how things would play out, what would be the politics of this legal institution. And as you know, the Clinton administration had not ratified, but signed the statute, and then George Bush, when he came into power, unsigned the statute.